Hello, everyone. My name is Joshua Gilliland, attorney blogger on Bowtie Law. With me today is Howard Reissner, the CEO of Planet Data, who's in New York. Howard, how are you today?
I'm great. Good afternoon, Josh.
Well, Howard, I looked at a presentation that you recently did for a large law firm that covered eDiscovery ethics and mobile devices. Awesome presentation, and I encourage anyone who would want to have this ethics CLE to reach out to Howard because there's a lot of good stuff in here. But today we're going to talk about the issues you identified in this presentation and their ethical implications. So kick it off for us, Howard, and what are the challenges and solutions you see with mobile device management?
Well, Josh, there's been a real change in really expectations of privacy and for individuals and companies over the last several years. Up until probably the mid-1980s, you basically had the Fourth Amendment, and you had some expectation of privacy, even though it's not explicitly written into the Constitution, except for the Fourth Amendment, which gives you the right for unlawful search and seizures. But basically, people had their personal information, and they had it in their home, and you couldn't just go into somebody's home without a warrant or something and request that kind of information. So personal was separate from work. Then we started to have email in the workplace along with personal, and you had the Stored Communication Act, which was passed in 1986. And essentially, that was sort of a shield for data that resided in a third-party facility. And that worked for a while. And then we started to move into the next generation of legal issues and practical issues, which was that people started to use mobile devices. So at first, it was pretty much a laptop that was supplied by their employer, and you sort of had the state laws that basically said, with some degree of expectation that the employer had a right to look at your emails and some kind of notice or provisions in a policy. You essentially didn't have much of a right of privacy using the corporation email. And that has now changed in the last few years, because now what you have is not only do you have employer supplied devices, laptops, tablets, phones, but in addition, because now essentially a phone and some of these devices have essentially become portable home computers with a repository for all your information, you've had people utilizing these devices for both personal and business uses, dramatically changing the landscape as to how data is stored, reviewed, used for work, privacy expectations with all sorts of legal permutations.
And there are many, because a smartphone today has more computing power than the lunar lander did in 1969 or a Commodore 64 in 1982. So just the sea change in technology is fairly impressive. Well, let's talk about the duty of competency. We've had a lot of action here in California because we have our proposed interim ethics opinion on eDiscovery that's gone through a couple changes, and comments are open now. We also have the ABA rules. But could you explain what is the attorney's ethical obligation to understand mobile technology in relation to their clients?
Well, in 2012, the ABA passed the 1.6. They had an amendment, which in the comments, which says that in addition to adequate representation means that the attorney has to stay up in front of changes in technology, and that has really played into the current landscape. If you take that along with Rule 1.6, which there was a new provision to Rule 1.6 that basically says that attorney has to take adequate steps to prevent the release of client confidential information, which will come into play not only on any client information that the attorney has, for example, on their devices, mobile devices, but also when they're counseling clients as to protect their confidential information. And then lastly, you had Rule 5.3, which essentially talks about non-attorney assistance, and that, in fact, in simple language, while the attorney is certainly allowed to delegate or to utilize third-party people either on their own team or outside providers, which is perfectly acceptable, they need to understand what those people's competencies are, and they are ultimately responsible for the actions that they perform. They just can't delegate it down and then later on say, well, I didn't know they handled this and I put them fully in charge of that. That is no longer going to be acceptable going forward.
Well, let's connect the two, the issue of mobile data to our legal and ethical responsibilities with client data. I have my short list of things that could go horribly wrong that lawyers need to be aware of. Could you enlighten us with your thoughts on this issue?
Well, only let's say from their own devices. So you're traveling, or you now have your client information on your phone, or you have it on your laptop, you have it on your tablet. So you have to take steps. Both the firm has to take steps, the attorney has to take steps to protect that information. There are various policies and procedures that you can put in place. Obviously, the best one, or the first one, is don't have confidential client information, on these mobile devices. If you must, you probably should make sure, number one, that a third party doesn't have access to it, that it's encrypted, that if the device is lost or stolen, that the third party doesn't have access to it. You can use software technology that if in fact that occurs, that you can remotely lock the phone or device, or in fact even delete the information if need be. Those are some of many steps that can be taken to prevent this kind of thing. I think the primary one, if you read a lot of the articles and cases coming down now, is that it really is enormously advisable to have the information encrypted at all times.
Let's talk about capturing this data. When I think of these issues and somebody has commingled business and personal communications on their phone, you might want to do a targeted collection, or if the hard drive on the phone could be partitioned, that could be a way to do this as well. What are you seeing in this issue for capturing information off of mobile devices?
Well, first of all, when we give the CLE, we have one of our certified collection examiners who goes along with me and prevents the technical piece of this. But first of all, I think before that happens, if there's an anticipation of litigation, you have to, as like any other data source, you have to put a defensible legal hold in place. Make sure that information is not spoliated on the mobile device. So I think that's first and foremost. Once that's done, it's quite a bit more complicated to target and access information from a mobile device, for example, than it is from a laptop or from a PC. So you need somebody that really has expertise in the tools that are able to do this adequately. Clearly there will be cases going forward, and there already are some in the mix, claimed spoliation of this kind of information. Even though in some degree, like on a laptop or something, on a phone, it's generally you can find it. You can find this information somewhere. It becomes far more complex to retrieve text messages and things from a phone. But to get directly into the last question is, somebody who is an expert in this area can take a forensic image of the entire phone, and then on a targeted directive go into various types of data sources. Obviously, the problem here is that, again, you have the commingling of the personal and the work, and that creates all sorts of issues on its own as to the ability of somebody in a litigation situation to request potentially access to somebody's personal information, which may contain all sorts of health issues or other types of communications which are private.
Very thoughtful. One of the issues that I heard about was with Windows type phones. 70% of the data is stored on the cloud, in the Microsoft cloud with those. Did your expert address that at all and the challenges with that?
Yes. We are seeing that as with bring your own device, which is now sort of being addressed. And now there's bring your own app, and there's bring your own cloud. And so here's some of the issues as you're trying to access this information. We get into inadvertent release of both personal and, if it's an employee, of corporate data. The employee may not even know when they access an app or when they are sending some of their information to the cloud, where that information is going, in what jurisdiction, what kind of protections, what's the ability to retrieve that information. Is it in one place? Maybe it's dispersed over numerous cloud sites. And so all of that, when you try now to retrieve this information, and it's commingled with both personal and potentially corporate information, you can see the complexities of this just grow exponentially.
Wow. So what are some of the data sources that we need to be aware of when we're looking at a mobile device?
Well, you have the obvious, people are accessing corporate emails. Then they may be also accessing, it's possible that they have another, their own personal email, Hotmail, Gmail address. I know.
Maybe a server at home in their attic. You never know.
Oh, well, but there'd be nothing on that. Why would anybody hide anything on their server at home? But so you have that issue, and then you have all the various places where people can store data. They may have various file shares, photos that they may be sending and exporting to a cloud environment. And so every one of these phones, and there was there was a case, United States versus Flores Lopez, which was in the 7th Circuit, 2012, and the quote is, "A modern cell phone is a computer." So all of the ability to store diverse types and voluminous amounts of information resides on this teeny little device that fits into your pocket now. It really is an entire new universe we're addressing.
Well, that, and if you were talking to someone from 1980, it would look like magic. With the way that we have this technology today, and like if you watch old programs from that point, time period, and if they were projecting what the future would look like in 2010 or whatever, some of them weren't even in the ballpark with what we have today. So it is fascinating what we have on our iPhones and Samsungs and everything else, that it's a wide range of information.
Let me inject one other, we didn't discuss this earlier, another fact that now, because we've now made this as simple as can be, let's make this even simpler. So not only do you have all this information, all these issues we just discussed, but now you have varying degrees of privacy concerns in various parts of the world. And in fact, in Europe and in Asia, they are far more concerned now than they were a few years ago about data privacy. The EU is in the process now of changing their EU 95 directive to make it more focused on the requirements to transfer information cross-border, especially to the United States. Okay, so now you have this phone. So now the scenarios where somebody's traveling multiple jurisdictions, they have this information. Where was the information created? Where was it accessed? Who has jurisdiction over the privacy issues? Whose data is it? If you had a U.S. citizen conversing with somebody in France, okay, is that now disclosing the personally identifiable information of the French citizen? None of these things are just the nascent stage of being addressed in the law today. The law is way behind the realities of what's going on in real life.
Wow. Well, let's talk about how to do this. So what are some of the techniques used to capture and analyze the data off of mobile devices?
Well, we do in our CLE, our CCE goes through some of the software and devices that we have that's able to isolate and take a forensic copy of this kind of information. I mean, that's really a topic to get into on the technical level. Suffice it to say that we do have these kinds of software and devices that in fact can access the information and record it in a forensic manner and bring it back for collection. I will tell you that in the CLE we gave 2 weeks ago, our CCE, Brad Berkshire, said that he's handled 10 collections in the last 6 weeks. And of those 10 collections, 8 of them contain mobile device collections.
Wow.
And that, something 2 years ago it might have been rare, infrequent to rare.
So what are some of the issues that lawyers should consider with mobile device discovery?
Well, I mean, some of it is whether it's if their own devices. We've already discussed about how to protect the inadvertent disclosure of their client's information. From a client's standpoint, they should be counseling them on policies and procedures. They should be counseling them on how to set up a mobile device management policy. So you can either do that if you have a sufficient IT infrastructure. You could do that with your own policies, such as first of all, you should should have a policy that is in writing, that is transmitted to all the employees, that they understand it, that they acknowledge it in writing back, that they agree to adhere to it, that they understand what is proper and improper use of the mobile devices, whether it's their own or BYOD or employer supplied. And they should adhere to it. And in fact, if there are violations of it, those violations need to be addressed and consistently applied. Okay, that's number one. Number two, and then and the same thing if there's a loss of one of these devices, how you're going to handle it. So if somebody loses it in a train station, what are you going to do? You're going to how can you remotely access it? Are you going to wipe it? How long are you going to let it go? What happens, for example, if somebody tells you they lost their tablet and you wipe the device and it turns out to have just irreplaceable personal information, pictures, family photos, and it's found the next day or not, and you've now wiped all this information from their phone, from their tablet. And then if in fact you do not, since most companies do not have the IT infrastructure to do these kinds of technical machinations, there are companies out there that have these mobile device management platforms that you can use as a third-party vendor, and they would then be, you would contact them when one of these breaches occur, and they could handle these situations. Nonetheless, I think the best advice that an attorney can give their clients is none of these things I just enumerated should be done without a transmission of the information to employees, acknowledgement on their part that they understand it, and written consent that they agree to adhere to it.
Very thoughtful. Well, let's look ahead because new toys keep coming out. Apple premiered their Apple Watch, not the iWatch, the Apple Watch yesterday. And I admit, I want one, and knowing full well that it could contain a ton of eDiscovery for employees, who could end up in litigation. So despite that, it's like people still want these things. What are some of your thoughts on the future? What can we expect?
Well, I think it's now pretty much agreed, and there have been a number of cases that said that anything that resides on these mobile devices is potentially discoverable. And that was some of the issues we went through some of the cases in our program. It's like anything else. It's amazing today that people still write emails that turn up on the front page of the paper when they're on notice that everything is discoverable unless you can somehow hide your email server. And so you have a situation here now. This is just another place where people can create and store information, and just don't seem to be aware that every piece of information that they create is essentially discoverable. That as we started this conversation a little while ago, expectations of privacy that you and I may have had in another day really have broken down and rarely exist anymore. And some of it is we have allowed, as part of this ability to have our entire life on our wrist, we have waived the right to privacy. We've waived it by acknowledgement, by consent. We agree in our either online or our written agreements to the policy or lack of privacy issues on these devices. And basically, we're allowing, every time we turn on our phone, we're allowing the GPS tracker to track us, where we are. And so it's little by little, the erosion in the right to privacy, to not be followed, to not be tracked, for our really each and every action almost to be seen by innumerable amounts of people and analytic machines has really disappeared over the last couple of years, and I don't see that trend changing.
Thoughtful. I agree with you, and I appreciate your thoughts on this. This sounds like a great CLE with the amount of detail that you can cover these issues, more so than in a podcast. Now, if people wanted to find out more about Planet Data or to see about having a schedule where this could be set up for you to come in and talk about these issues, how can they reach you?
Well, you can reach us at www.planetdata.com. Go to our website, and you can contact us. We'd be very happy to do that.
Perfect. Well, Howard, thank you so much for your time, and I appreciate our discussions. This is always very enlightening, and thank you all for tuning in today.
Thank you, Josh.
Take care.